Awesome. So in a mutual non-disclosure agreement, it's two-way, so it's bidirectional. So not only am I going to disclose to Victoria my confidential information, but Victoria is also going to share with me her confidential proprietary information, right? And so it's mutual because we both make a mutual promise to keep confidences. So I'm going to share with Victoria my secret process, and she's going to share with me her secret know-how, and we agree to keep that confidential. So we're not going to disclose what we disclose to each other, to third parties. And again, the reason why we might want to enter into such an agreement is so that we have an opportunity to explore possible business opportunities, right? So Victoria might have some specialized skill. She might be really good, for example, so she's an expert at windshield wipers. And I, on the other hand, my company might actually develop the rubber material that goes on the windshield wiper. And so now we might want to share our secret know-how to see if there's a way for us to develop a joint product, because Victoria has extensive experience on repairing and servicing windshield wipers. And so she might know of a special technique that we can possibly use to prolong the life of windshield wipers and decrease their mean time between failure, right? So we're going to combine our expertise. My company does rubber process and material, and Victoria is an expert in servicing, and so she knows about how they fail, and so we might collaborate. So I'm going to tell her about my secret processes, and she's going to share with me her secret know-how, and we're going to see if there's possibly an opportunity for us to develop a joint product together. Okay, so one thing that I have going here is a sample mutual confidentiality agreement. So what I'll do is I'll go ahead and I'll share my screen. All right, so here's our mutual confidentiality agreement. So we're going to enter into this agreement. We'll assume that we're going to enter into it as of today. So today is the 15th day of September. Whoa, whoops. 15th day of September, September 2020. So let's just say, let's say that I have invented a new process. So I'll be the entity. So Amir, so I'll do my initials, okay? I'll do AVA Material Corp, let's just say, okay? And we'll do Victoria Windshields. How about Windshields RS? Awesome. So Victoria is engaged in the business of developing windshield services. And I'll be the entity that is busy developing windshield materials development services. So let's see how we can work together. So in this example, I've invented something. So I'm the sole inventor. Let's just call it the material. I'm going to give it some code name. Just call it, I'll just give it my initials, Matt1. This is me. You guys know my last name already. So windshield material, windshield wiper material. I gave it the code name AVA Mat1. And I've assigned it to my company. So Victoria knows that my company, AVA Material Corp, owns my intellectual property described in a patent application. Now, in this hypothetical, the patent application isn't yet public, so everything that's in it is still confidential. So it's technically still a trade secret. One of the ways that companies and inventors sometimes protect their know-how is by filing a patent application. But they intentionally file what's called a non-publication request. So that a non-publication request prevents a patent application from publishing and becoming public record. So when you file a non-publication request, and note, you have to file it the same day that you file the patent application. But by filing a non-publication request, you essentially maintain the contents of that patent application confidential up until the patent application issues as a US patent, which could take several years. So in this example, what I've effectively done is I filed a patent application, and that delineates what it is I believe my invention is, and also defines what that invention is clearly in a written document. So what I'm probably going to do in this situation is I'm actually going to, once Victoria signs this agreement, I'm going to send to her my patent application, which describes my novel material. And she's going to evaluate it, and she's going to share with me what know-how she has, and we're going to see if we can develop a mutually beneficial product together. Awesome. So we're, and again, this is the key language. This is the whole purpose right here. So it's the possibility of entering into or pursuing a relationship for basically for manufacturing, basically for development, for making money out of this product. So I have this product, and we want to see if there's some way that we can work together. So in order for us to engage, we're going to have to exchange confidential information, right? So here's the disclosure and exchange of certain non-public and proprietary information, right? So that's the key. So we're gonna be sharing confidential information. I'm going to share it in the form of my patent application. That's pending and confidential. Very important, confidential. If my patent application had already issued as a U.S. patent, right, then it would be published and it would be publicly known. It would be available to anybody. And so then that would no longer be considered confidential information. But in this hypothetical example, I have a pending patent application that covers my special rubber material that I think is really, really useful for windshield wipers, okay? But it hasn't yet published, and it's never going to publish. We filed a non-publication request. It's going to remain confidential, and it's going to remain so until I decide, and until the patent office issues what's called a notice of allowance, giving me the opportunity to issue the application as a patent. But until then, it is considered a trade secret. It's confidential, and I haven't told anybody about it, except I'm about to tell Victoria. But before I can tell her, we need to enter into this agreement so that I'm confident that my know-how is still kept confidential and proprietary. So we both wish to preserve the confidentiality and prevent the unauthorized disclosure of the confidential information. So again, Victoria is going to share with me some confidential information as well, right? So let's look at some of these terms. So the first term that we have to define is what confidential information is. Now, this is a very, very broad description. So it includes data, materials, products, product concepts and design, prototypes, devices, inventions. So really, really, really broad language. And look, it even covers manufacturing information, business plans, advertising, marketing, and promotional plans and materials, pricing information. Pricing information is going to be huge, right? Supply lists and customer lists. These are going to be really, really valuable, right? Because remember, Victoria is an expert in servicing windshield wipers. So she has a big list of possible contacts. She knows a lot of people in the industry. She knows her competitors. She knows a lot about pricing, about what the value is of a windshield wiper, how long it lasts, how long they tend to last, what it costs to replace one. And she probably also knows information about profits, right? About what the profit margin is for windshield wiping services. So she has a lot of valuable secret know-how. She also, not only does she know information about her competitors, but she might also know information about downstream or upstream suppliers of windshield wipers. And so she has a lot of confidential information that maybe isn't necessarily technical, but is still confidential and secret and not commonly known. And keep in mind, if someone were to get a hold of this confidential information that Victoria knows about the business, that could be detrimental to Victoria's business, right? That's the key. So the fact that Victoria has all this confidential information, whether it be pricing, customer lists, or techniques for marketing and advertising, that's valuable information that brings value to Victoria's business. And so if it gets into competitors' hands, then it might harm Victoria's business, right? Because now other competitors that have this information can use it to compete against Victoria's business in the marketplace, right? So that's the key. That's why these agreements are so important, because Victoria needs to keep this information confidential, but she needs to share it with me because we need to see if there's an opportunity for us to join forces, per se, and work together to develop out this product. So again, confidential information doesn't necessarily need to be technical in nature. It doesn't necessarily need to relate to a patentable invention. It can be customer lists, all this various information that is really valuable and critical to Victoria's business, and that if a competitor got a hold of would harm Victoria and give them a competitive advantage. So there's information that's going to be exchanged. We're going to trade information. And this is really important. So we're not saying that we necessarily are granting each other rights or license this information. We're solely exchanging this information so that we can see if there's an opportunity for us to work together. Now, that doesn't preclude the fact that we might at some future date actually enter into a license agreement. But just for the purposes of our initial conversations and discussions, we want to be able to enter into these exchanges comfortably, knowing that what we tell each other is going to remain within the confines of our conversation and discussion, right? And the fact that I disclose my secret rubber process to Victoria doesn't necessarily mean that I'm granting her a license to then go off and use it without my authorization. So it's really important. So we're not exchanging rights or licenses in any of the confidential information. We are, though, promising that we're going to keep them confidential. So again, confidential information, it's really important. It can't be publicly known, right? So this section here defines what is not confidential information. So anything that's publicly available or publicly known is not going to fall under the confidential information definition. And again, publicly available, anything that is available that someone isn't under a duty to keep confidential, these are not going to be confidential information. Or lawfully obtained. Again, if it's, again, court, yeah, so basically if a court basically says that it's not confidential, independent development is a really big deal. So if through, let's just say that I disclose my secret material to Victoria, but she can show that she independently developed that product before I told her and without any of my input, then Victoria, technically, that would not constitute confidential information. So that's a really, really important point. And by the way, that can happen after, as long as she can show that it was done by independent development. However, it's going to obviously be hard for her to establish that she didn't benefit from my disclosure, right? But if she can show that she developed it independently before I told her about it, and if she has documents to establish that, then she probably has a pretty good argument that it was developed independently and that my disclosure would no longer qualify as confidential information. So you got to be careful. I have to be aware of how savvy Victoria is, and how much into R&D she is, because she might be really into research and development, and she might already know about the secret rubber process. And so by me telling her, I would only basically show my hand without necessarily getting any protection for that. So that's important to keep in mind. So that's basically the essence of this agreement. There's limits. Again, these are all contractual, so we can agree. This example here has 5 years, so we're not going to disclose any of the confidential information for 5 years from the effective date of this agreement, and we won't use it. So again, you can be longer. We can negotiate that. We can say 15, say 10. It really just depends on our comfort levels and how interested we are in maintaining this information confidential. The clause number 5 is really important. This basically limits who has access to the information. This basically requires, for example, all of Victoria's employees to also be subject to confidentiality under this agreement. So if her employees somehow get a hold of the information that I disclosed to Victoria, this is requiring Victoria to also impose the same restrictions on her employees as apply to her, right? Because it wouldn't be fair if she could just tell an employee and that employee could then exploit my confidential information, and vice versa, right? So this also applies to the information that she provides me, right? And so the confidential information that she provides me, I can't just leak through an employee, because that wouldn't be fair. 6 covers property. So any confidential information that I provide to her, let's just say in terms of if it's on old school drives, digital records, documents, papers, presentations that are printed out, any physical material, prototypes, for example, that all belongs to me, and vice versa. So the confidential information that Victoria provides to me, whether it be in the form of documents, printed documents, digital documents, however it may be, it's going to remain Victoria's property. So that's really important. And notice it also applies to copies. So copies made as well, they're also going to belong to the disclosing party. This covers the fact that Victoria might receive information from another party that is similar to the product that I'm proposing. So the AVA MAT1 material, remember, there might be another company in the industry that's developing out a similar product, and they also might want to disclose it to Victoria in a similar type of arrangement. But Victoria, it wouldn't be fair to hold Victoria accountable for that, because this is a third party that possibly developed independently a material that's similar to mine. So we can't expect Victoria to have confidential information to apply to that product as well under this agreement, right? Because that's a third party that developed it independently of me, and then independently of the information that I am going to be providing to Victoria. So this protects her, and in both ways, right? Because Victoria might provide me information, and I might get that information from a third party at some future date, but I shouldn't be held liable for that, especially if there's no wrongdoing and there's nothing that I did on my part to disclose any information that Victoria provided to me, or vice versa. Again, it can only be modified by writing. The rest of this agreement is largely standard language. It defines choice of law provisions. So in this case, we're in California, so we like to have California law. But as I said yesterday, remember, it's really important to consider choice of law provisions, because if Victoria, let's say Victoria is in Nevada and she's entered into agreement where she's bound by California law, let's just say she's in New York, right, cross country. Now, if this issue ever gets litigated, I could hail her into court here in California. So that's a serious consideration, right, Victoria, because you don't want to have to fly out all the way here, seek counsel here, have a active court proceeding here in California if you're based in New York. So that's something to think about. You always want to think about choice of law provisions and where you're subjecting yourself to the laws. So something to keep in mind. So if we're both in California, obviously it's a lot easier. If we're in the same part of California, even easier, right? Choice of law, we're not going to really get into a dispute as to where the choice of law should be. So that's a mutual NDA at the highest level. Again, it's a really, really good opportunity for us to possibly see if we can work together and see if we can explore business opportunities, to see if there's an opportunity for us to join forces, combine our know-how to develop a really, really awesome product. Oh man, do NDAs typically have arbitration clauses in them? That's a really good question. This is a really good question. So again, this is something that we can decide on beforehand. So we can agree to have an arbitration clause. Oh wait, let me show the question. Oh, my bad. So the question about arbitration clauses. So arbitration is essentially an opportunity for us to avoid the court and try to arbitrate any dispute that we might have. So we can agree to that, but we both have to. We're basically waiving our rights to jury trial if we go the arbitration route. So that's something to consider and think about, and it's something that Victoria's going to have to evaluate as well. But they tend to be binding and final, and so it's something to think about. And then there's a second question about litigation in state court. So state court. So for state court, so yes, generally they are litigated in state court, which is why we were talking about choice of law provisions. So if Victoria were to somehow disclose my information to a third party, then I would sue her in California state court. However, I could actually sue her in federal court if she were out of state, right? And so that's something to think about. And there's definitely considerations about being in state court or federal court. Generally, federal court, tends to have more streamlined and formal procedures. State court, less so. Some practitioners prefer federal court over state court because there might be experts in federal court and vice versa. So you might have practitioners that are experts in state court And so they're obviously going to prefer state court because that's where their expertise lies. So a lot of this is just choice. That's the beauty of these agreements, is that they're really contracts at the end of the day. And so we have a lot of latitude as to how we want want to deal with possible disputes and conflicts with the agreement. So that's the key. That's the beauty of it. We're free to contract as we please. And so Victoria might have opinions about some aspects of how disputes are handled. And I might have my own opinions, and it's just a matter of coming to an agreement, meeting of the minds, as they say. And so this is an opportunity for us to contract and engage in a contract where we're protecting our confidential information and know-how. And so it's just about coming to terms upon such an agreement. And part of that is, as the Fours Invasion pointed out, we have to decide where and how we want these disputes handled. So, but that's the beauty of it, right? Free contract. So it's pretty cool. And again, really important, really important. The remedy for breach is, sorry, the remedy for my remedy is to sue for breach of contract, and vice versa. So if I disclose confidential information that Victoria has disclosed to a third party, then her remedy would be to sue me for breach of contract. So, but essentially the Defend Trade Secrets Act creates a federal cause of action for disclosure of trade secret. And by the way, there are notice provisions for the Defend Trade Secrets Act. So I think we should do some episodes on that, because I think it's going to apply to a lot of you, especially those of you who have businesses with employees or engage with contractors, right? So in this hypothetical, Victoria wasn't a contractor. We were really trying to see if there was a way for us to work mutually together in developing out a product. But a lot of you are going to hire experts like Victoria, as contractors. And so you want to be sure to have protection under the Defend Trade Secrets Act as well, as a possible remedy. So yeah, really good questions. So thank you so much.